Fine, brother. Yeah, good morning, Aisa Shamsa. Well, let me attend some of the important questions when we left on the last occasion. And before I proceed further, I formally welcome you all and a very, very warm good morning to all of you. Yeah, Mr. Mohammed Imran, you were saying something regarding artificial intelligence, if I'm not wrong. And that was very much relating to the persecution, and that is one of the most important component that is still remains to be deliberated upon. And I would be proceeding with that particular component today. So if you recall, what exactly was your question, my dear friend? Yeah, Mr. Imran.
Yes, sir. Thank you, sir. So my question was, uh, even if we employ the artificial intelligence for the purpose of prosecution or refugee, or to say to identify the genuine refugee and those who are not genuine, uh, there are certain things which I believe that AI cannot recognize, because AI essentially works in numbers, like binary numbers. So how will AI quantify the essential aspect of refugee? For example, a state can make a policy that people from this country do not qualify as refugee, even though in reality they are fleeing from the persecution. So if we put a data in any AI to identify a refugee, which is already biased, so how we are going to deal with those situations?
Yeah, that is a question which I have answered in my writing. I was also grappling with the same kind of dimension. And you have rightly identified another important gap as per your investigative, jurisdictional, as well as the juridical trajectory. It is one of the most important questions, not only you, but each and every jurisdiction, each and every region, and all the scholarship which is available in these regions, whether it is European or the Afro-Asian, global South, global North, whatever may be the divisions for our understanding, but the scholars have been asking these kinds of questions. AI or artificial intelligence also suffers from certain important gaps, certain important discriminatory practices, certain important targeted discriminations, prejudices, ill-conceived notions, and biases. Because if you go through another important area that is emerging at international level, that is software information law. That is another important field which is going to establish itself as an independent branch of human engagement in the umbrella of law. So we cannot, because there is a programming of softwares. There is an application of specifically designed softwares that has created a lot of problems, because the questions of genetic privacy, genetic modification, DNA profiling, if the racial profiling, if these are going to be embedded in the softwares and there is an encryption and these softwares are applied with this kind of an ill-conceived notions peopled with racism, revanchism, and genetic identifications, then definitely we cannot ensure equality, we cannot ensure the rule of law, we cannot ensure the equalizers in the determination of refugee status on the basis of mechanical application. And these kinds of decisions, which are popularly known as automated decision making or automated decision mechanisms, they are bound to err. So we cannot expect, and that is the biggest disservice of robotic application. And therefore, machine learning, deep machine learning, or computer languages, they are basically programmed, and they are programmed by the highly specialized artificial intelligence engineers who have to take into account the governmental nuances and governmental predilections and choices. And on the basis of those, these programs are generally designed. So it is a very, very fundamental, question that has created a lot of, problems in artificial intelligence. And that is why people are not comfortable with the application of the artificial intelligence. And people have been trying, my dear friends, that the concerns of human rights, humanitarian terrain, and entire human rights terrain, that should also be taken into consideration while designing these applications of software, especially designed for the application of artificial intelligence, or whatever the, as you have pointed out at the very initial stage of your arguments, Mr. Imran, that it is basically an application of numbers. We may call it algorithmic numbers, and on the basis of algorithms, this entire what you call terrain of artificial intelligence is manufactured. So that creates a lot of problems. So we cannot. And I am of the view, personally speaking, that everything cannot be handed over to machines, because if you take into account one of the finest movie that has been produced by Hollywood, that is the rise of machines, Terminator 3, I think that is the caption. When I was seeing this movie, I was also having a lot of questions relating to artificial intelligence, because the people for the last more than 20 years or even prior to that, people have been, or scholars have been writing on artificial intelligence, emergence of the artificial intelligence, as well as the incidental issues, the connected issues, related issues, associated issues, which we have been receiving, rather we are confronted with them as some kind of additional dimensions. And that is why on the basis of these concerns, so new softwares are being developed. Governments have also ordering the development of these kinds of softwares just to perpetuate themselves into authoritarianism. So a lot of questions relating to democracy, rule of law, human rights, refugee rights, climate change, even the genetic modifications, medical sciences, as well as what you call, we are also using robots in medical debridement surgeries and other important facets of the medical sciences. So we cannot run away from the application of artificial intelligence induced, or driven softwares. So we have to revisit the entire, umbrella or entire, field of artificial intelligence in the light of legal analytics, as well as in the light of human as well as the human concerns, rather I should say. So this is how we should and we are supposed to revisit, and these are the challenges as well as the concerns which I have also raised, and we are still in the process of finding the plausible, pragmatic, and reasonable solutions to these kinds of softwares, and respond, I mean, while responding to these kinds of concerns, again we have to convene some important what we call deliberative meetings, and people are organizing such kind of seminars, I mean conferences, workshops, where even the multidisciplinary, I mean scholars, they are also coming, and there is a gathering, and many conferences are taking place to address these kinds of nuances and dimensions of artificial intelligence. Any further observations, Mr. Imran, from your side?
Hello.
Yeah, hello.
Sir, thank you for the clarification, sir. Of course,
Yeah, I'm going to share. I'm going to share in the next week, because I'm also, waiting the, officially published what we call, version of my, submission. Though I'm having the PDF copy of, from the editor's, desk. So I'm waiting for that very, copy, the official one from this very journal, because the only the title, name, volumes, dates have been, shared with me without any kind of, I mean, the official copy, and that is the part of this international journal. So I am waiting, and immediately I will share with all of you. Yes, I welcome Mr. Prakriti Malla. She has also raised a very important question on the last occasion, and she was of the view. I think she was talking of persecution, if I am not wrong. So may I draw your attention, Ms. Malla, and request you to raise your question when we actually, engaging on the last occasion. So I put a request that I would be, beginning my today's deliberations with your question. So what exactly was your question?
Sir, it was more than a question. It was my opinion, and that was
Yes.
related to persecution. And we
Yes.
were basically discussing about what the persecution is and what the well-defined fear is all about. So, what
Mm.
my opinion is, sir, the persecution, it has not been clearly and precisely defined under the Refugee Convention. So, I believe that there are sufficient ground to accommodate the new challenges that is coming out in the form of persecution. Like as you said, now new form of refugee are emerging on, which were not during the 1950s. In 1950, we understand that refugee were only the someone who used to fear, who used to face a persecution because of war. But now even the climate refugee comes under it. So I believe that the non-defining of persecution in the Refugee Convention has given a sufficient ground to accommodate even these new challenges. But it does not mean that everything is open-ended. There should definitely be some like limitation within the meaning of the term persecution. Otherwise, like if everything is left open-ended, then it may also create arbitrariness. That's why I believe like the well-founded fear, the terminology used in the Refugee Convention and the persecution has to be defined complementarily, not in isolation, so that
Okay.
each other definition can be limited.
Yeah. Thank you. Thank you very much for your observation. And another student, I think I am forgetting the name, that, on the last occasion, yes, threat to life, no war in North Korea. These were the, examples which were, shared. I think one of the students was of the view that I think he was making a reference, if I am correct in my recalling, that the persecution and particularly the protection of the war refugees, that is equally important, as well as threat to life, that is another important dimension. Now I take you to this entire controversial component. Controversial in the sense that we do not have any kind of a definition of the term persecution. But my dear friends, it is important at this stage, and we are not here to challenge the collective wisdom of the drafters of 1951 Convention relating to the status of refugees with its additional protocol of 1967. But what is important and what should be important at our disposal, as if I am allowed to take a cue from Ms. Prakriti Malla's observation, that the element of complementarity constitute one of the most important, discernible, conspicuous aspect of, or it should be our understanding with this particular element. Because in the field of international human rights law, in the field of international refugee law, in the field of international criminal law, or in the field of international humanitarian law, as well as customary international law, it should be the most important understanding of all the scholars, including people who are engaged right now in this online class, that the element of complementarity and supplementarity is one of the most important aspects of the dynamism of law. Law should never be studied in exclusion, and that should be the rare situation when we are talking of any kind of a special application of law or contemplating some kind of a specific situations of law. But so far, the application of international refugee law is concerned, my dear friends, as I have been submitting for your consideration, and if you take into account the cumulative application of all my submissions from the day one, you will realize that international refugee law does not mean these two important instruments of 1951 UN Convention relating to the status of refugees or its additional protocol of 1967. Rather, the entire understanding of international human rights law, whatever the pool of instrument is there, including the 4 Geneva Conventions which constitute the subject matter of international humanitarian law, and other important branches of international law, including international constitutional law, comparative constitutional law, or constitutional law per se. They should be understood as the bedrock of our entire understanding of international refugee law. And with this element of complementarity, we should find out certain important possible solutions for the refugees. Because as my friend Mr. Muhammad Imran has also argued in his synopsis, that how to decrease what may be the possible avenues for the decrease in the numbers of mounting pressure of refugees. And very rightly he has framed his research questions as well in his synopsis. And with the framing of these questions, he has identified certain important golden silences which are very much there. And one of the golden silence, Ms. Prakriti Malla, you have also identified. If you take into account, and I really consider this kind of a gap, that fortunately I should say we don't have any definition of persecution. Though sometimes it becomes very, very important to have a definition, because we are able to determine the province of or operating, what kind of a operation of law should be there, what kind of an application of law should be there, what should be the functionalization of law, what should be the functional value and application of law. And this is only possible when we are having some kind of a definition of something or some aspects of law. It is very, very important, and it should be taken as a blessing in disguise, my dear friends, that we don't have any kind of a definition of this particular terminology called persecution. Therefore, instead of defining we should try to concentrate what exactly or could be the characteristics of this terminology which is known as persecution. So I have identified certain important structural, I mean, demarcations, as well as some other important facets of the term persecution. In my understanding, I have identified as many as 4 important dimensions, or you may call it the characteristics of this particular term persecution. Number one is structure of harm. When we are talking of structure of harm, please do not jot down anything. I would be sharing each and everything with all of you. Even today itself, I will share, I promise. There would not be any delay. Structure of harm. We should try to understand what exactly may be the structure of harm, what may be the demarcation of harm, what may be the visage of harm, what may be the form of harm, what may be the logic of harm. And this should be defined on the basis of, my dear friends, or in other words, we can put it like this: credible apprehension. It means credible apprehension is, it means there should be some kind of a credibility of a person, of an applicant who is making and voicing his concerns that he is having some kind of a well-founded fear or well-founded apprehension. So on the basis of this averment, the credibility of this kind of a submission or this kind of a deposition should be what we call assessed with an element of structure of harm. So that should be the deciding factor. And the second important characteristics which I have identified, and that is I call it adequate severity. I mean, adequate severity, you may also call it. I have also coined another important terminology for it, and that is the persecutory mistreatment. Mistreatment, misbehavior may be there, but does it amount to persecution? So we have to identify the degree, the threshold, the level of what we call of the mistreatment, intensity of the mistreatment, province of mistreatment. So whether it is going to constitute the good ground, adequate ground, enough ground to determine what may be the what you call dimensions of persecution. That is the second important characteristics. The third characteristics, my dear friend, is evidentiary standard. We have to appreciate the evidence, whether that is having some kind of a conformity with the standard that has been set out by the United Nations High Commissioner for Refugees handbook that has been designed to determine the refugee status, whether it is what you call malleable, whether it is changeable, whether it is what you call volatile. So is there any kind of a certainty that has to be rummaged, that has to be cajoled? Another important characteristics could be, my dear friends, that is the substantive nature of harm. Whether we find that it is having some kind of a substantive character of harm, whether it is having some kind of a element of normativity, that should also be appreciated to determine the reach, application, province of persecution, because it should be the exclusive benchmark when we are going to determine, I mean, the different aspects of persecution. This reminds me of a very important decision that has been delivered by the US Court of Appeal for the 9th Circuit. This is the case Carabellina versus Immigration and Naturalization Services. So in this particular decision, US Court of Appeal for the Ninth Circuit has identified, my dear friends, and that is there are certain important terminologies which have been used in this particular decision, and that is persecution may be found, my dear friends, by cumulative specific instances of violence and harassment towards an individual and his or her family members. Cumulative specific instances of violence and harassment to a particular individual, members of his or her family, but there has to be some kind of a pattern. There has to be cumulativeness, specific instances of violence and harassment. This has been pointed out in this particular decision, that is Carabellina versus Immigration and Naturalization Services in United States of America. Another important decision that has been delivered by the New Zealand Refugee Status Appeals Authority, and that is a refugee appeal. A number has been provided of this refugee appeal, and that is of the year 2000. In the month of August, this appeal has been disposed of, and it has been identified in this particular refugee appeal that the core norms of international human rights law are relied upon to define forms of serious harm within the scope of persecution. Here lies one of the most important argument which we have been talking, which I have been talking, which Ms. Prakriti Malla and Mr. Muhammad Imran has also added. So these inputs, it means we have to take into account the entirety of the international human rights law instruments when we are going to define persecution or extend it, or going to extend some kind of a relief to the refugee status claimants or applicants or the people who have been seeking asylum and fleeing persecution from their country of origin. So this should be taken into consideration. Another important decision is also there, and this decision is R versus Secretary of State for the Home Department, and it's an ex-parte decision, and it has been decided by the UK House of Lords in 2001. It has been opined in this particular decision, my dear friends, that for the purposes of 1951 Convention relating to the status of refugees with its additional protocol of 1967, persecution may be by bodies other than the state. Persecution is not limited to cases where a state carried out or tolerated the persecution. It encompasses, the persecution encompasses instances where a state is unable to afford the necessary protection to its citizens. So even state also commits persecution, my dear friends, because you might have heard as a student of law one famous expression which has been used by the students, teachers alike, with equal what you call vehemence, acts of commissions and omissions within inverted commas. So if you take into account the acts of omissions and commission or omissions, they have also been branded contrary to law. They have also been branded as offenses, as crimes. So if a state is not in a position, or a state fails to perform its duty towards its citizens in hostile situations and not able to protect the lives and property of its citizens, that amounts to persecution. or if there happens to be some kind of a targeted discrimination. I am deliberately using the word targeted discrimination as a form of unwritten policy, as not the part of what we call of some legislation or some kind of a. In some situations we have also came to know that there are some norms, there are some policies, and there are some, I mean, ordinances, some legislation, some enactments have also been there. And on the basis of those premises, even the state could also be squarely held responsible for the plight of its own citizens. Suppose take the example of the state of Pakistan, where the Ahmadiyas have been declared non-Muslims. Very well understand what kind of a state behavior has been there. So state is responsible because state has failed to provide any kind of a protection, safety, which is a guaranteed right as per the Constitution of Islamic Republic of Pakistan. So in the same what we call manner, in this particular decision, that is R versus Secretary of State for the Home Department, that as per the 1951 Refugee Convention, my dear friends, persecution may also be done by other bodies, by bodies other than the state. So in such a situation, what kind of a remedial measures are available? So state may be held responsible for the for the acts of persecution. Another important decision I should cite at this stage, and that is relating to again, that is a decision relating to what we call Australia. In Australia, in Minister for Immigration and Multicultural Affairs versus Howard, that is a decision of the 2002, where persecution consists of two important elements: the criminal conduct of the private citizens and the toleration or condonation of such conduct by the state or agents of the state. And that resulting in the withholding of protection which the victims are entitled to expect. Then the requirement that the persecution may by reason of one of the convention grounds may be satisfied by the motivation of either the criminals or the state. So this is another important dimensions, and you are legally well informed enough, my dear friends. You can understand that there have been situations, a similar situations in other jurisdictions as well, where we understood, we have vicariously witnessed, we have been privy to certain important writings, and there have been writings on the wall. And the biggest wall in today's contemporary world is internet, where each and everything is visible and we can study, we can what we call take note of. And therefore these two elements are present in majority of the jurisdictions at international level or across the jurisdictions or the world jurisdictions. Criminal conduct of the private citizens, my dear friends, and that is tolerated by the state. I should not further mention who are the states, you are well acquainted. Second element, and that is persecution of convention grounds. It means the state is responsible for that. So both the grounds are available. And that is why I call them as a new category, state-tolerated actors, state-patronized non-state actors. So whatever may be the nomenclature, but the result has been persecution. So how we have been witnessing this kind of persecution, that should also be taken into consideration, and it is very much axiomatic from this 4 or 5 important decisions from different what we call jurisdictions. All of us have understood, my dear friends, that we do not have any kind of a legal definition of this particular term, that is persecution. Because we do not find any kind of a definition either in the convention. So I am talking of the Refugee Convention of 1951. It is not at all available. I have also studied the preparatory material that was used, that was for the convention, which is popularly known as Provex Preparatories. So we do not find any instances or any attempt to define this particular terminology or term that is known as persecution. United Nations High Commissioner for Refugees confirms that there is no universally accepted definition of this particular terminology. In its various statements, even UNHCR is of the view that persecution has not been defined and it does not have any kind of internationally accepted notions of definition. However, as I have been telling, various attempts to formulate the definition of persecution have been made, but with little success, or with no success in certain important situations. There is a general agreement, my dear friends, that treatment must attain a certain degree of severity, as I have pointed out when I have identified the 4 important characteristics upon which the threshold should be determined. I'm sorry, there is a connectivity issue today. So I am intermittently I am losing internet connectivity. So I am really very sorry if I think a moment ago you haven't heard anything from me. Am I audible to all of you?
Yes, sir.
Yeah, thank
Yes,
you.
sir.
Thank you. Yeah, thank you. A judicial view, yeah, thank you, Mr. Suyesh. If we will take into account the judicial view regarding persecution, then the judicial view is that the persecution connotes injurious or oppressive action. The problem with such a narrow and little approach to the meaning of persecution is that the institution of asylum as a whole faces impediments and constraints which threaten the humanitarian spirit of the 1951 Convention. Therefore, formidable challenge to broaden the conception of persecution in order to constitute or continue to provide sanctuary to refugees have to be faced, have to be confronted with head on. One such challenge, my dear friend, is the linkage between human rights and the refugee regime. As I have been telling you, the concept of persecution cannot have remained unaffected by subsequent developments in the law relating to human rights. Any meaning that has to be given to the concept of persecution human rights standards or international human rights obligations, the dominant, though not universally accepted approach, but it is considered to be a dominant approach to the interpretation of persecution is the human rights based approach, or you may call it HRBA. So that, HRBA or the human rights based approach to persecution is definitely going to serve our purpose and to appreciate the criticality, credibility, or the structure of harm, as well as the apprehension or credibility apprehension, and whatever the characteristics I have submitted for your consideration. Everything has to be viewed through the lenses of HRBA, that is the human rights based approach. However, many scholars argued that logically the reference to the Universal Declaration of Human Rights, and that is a reference in the preamble to the Refugee Convention, my dear friends, implies that the drafters wanted the refugee definition to evolve in tandem with human rights fundamental principles. So a linkage has been established, my dear friends, that there is a relationship between Universal Declaration of Human Rights, because the element of the substantive character of the Universal Declaration of Human Rights, the normative philosophy that has been inscribed in the annals of the Universal Declaration of Human Rights does have a coterminous relationship with the idea of what we call refugee protection. So it is the fundamental normative principles which have been incorporated, encapsulated, and reflected in the preambular propositions, as well as in the 1951 convention relating to the status of refugees, must be what we call studied in complementarity. And on the basis of this complementarity, the protection of the refugees should be pursued further. Therefore, however, there are differing what we call opinions to which human rights ought to be considered in this particular approach, and that is HRBA, and what type of violations will amount to persecution. It has to be what we call further rummaged by the application of HRBA, that is the human rights based approach. On the last occasion, one of my friends have also pointed out that threat to life. Therefore, a threat to life or freedom on account of race, religion, nationality, political opinion, or membership of a particular social group is always persecution. There is a cumulative understanding. If you analyze the entire what we call instruments, the pool of instruments which is available to us in international human rights law framework, then these are the most discernible, credible grounds. Number one is the racial discrimination, threat to life, political opinion, membership of a particular social group. So they constitute, or if there is happens to be any kind of a violation on these grounds, that amounts to persecution. That is the basic and the most fundamental understanding under HRBA. Though there are, I'm not denying that there are other serious violations of human rights, and these other violations of human rights are or rather I should say for the same reasons, would also constitute persecution. Let me give you some of the examples from different jurisdictions. In United States of America, persecution is understood, my dear friends, as the infliction of suffering or harm upon those who differ in a way regarded as offensive. Difference may be there in terms of race, in terms of religion, in terms of political opinion. So if there happens to be any kind of a difference, and that difference becomes some kind of a bone of contention, and some kind of a discrimination is perpetuated or committed on the basis of these, racial differences, religious differences, or some kind of a differences in the political opinion that amounts to persecution in United States of America. Another important example could be taken from, New Zealand. New Zealand basically, adopted, or rather I should say adopts, Hathaway's, approach. James C. Hathaway. Right now, if I am not wrong, because as per my, email communication, presently he is working in the University of Michigan in United States of America. So if you take into account Hathaway's, approach that we find in the program and policies which are generally pursued for the protection of refugees in New Zealand, refugee law ought to concern, within inverted commas, my dear friends, I should, tell you, within inverted commas, the refugee law ought to concern itself with actions which deny human dignity in any key way that the sustained or systematic denial of core human rights is the appropriate standard. So, Professor Hathaway has identified an appropriate standard. An appropriate standard as per his, articulation and calibration. If there happens to be any kind of a systematic, sustained denial of core human rights means the dignity, human dignity. Persecution. So that should not be what we call on the basis of, as we have been, witnessing in many South Asian jurisdictions, that there is a, denial of human dignity to a particular section of people on the basis of, political opinion, on the basis of their social origin, on the basis of their faith, on the basis of, their membership of a particular, social group. So these are the, grounds which we generally, witness in South Asian jurisdictions. And there happens to be a sustained, systematic, organized denial of state protection in South Asia. So that should also be taken into consideration, because if the South Asian jurisdictions are, happens to be in violation of international human rights standards or international human rights treaty obligations, or in violation of customary international law, they are basically in violation of refugee rights as well. If you take into account, let me give you another important example from the Supreme Court of, Canada. Whatever we have, understood from the such jurisdictions like the jurisdiction of United States of America, New Zealand, Australia, you will find that the Supreme Court of Canada is also following the same kind of identification and following this HRBA premise to determine refugee status, to extend some kind of a humanitarian assistance to refugees. Therefore, it has also been, opined further by the Supreme Court of, Canada, that there might be a need for a sustained and systematic denial of rights where discrimination and cumulative grounds, so far the cumulative grounds are, concerned, but all jurisdictions recognize that persecution itself can also constitute a single act. So, the critical appreciation of this terminology or expression that is known as persecution, it is sufficient to constitute persecution. And on the basis of this kind of, identification, the relief should be, granted. If you take, let me give you another important, example from Australia. You will find persecution has been defined in Australia in a particular, piece of legislation, which is known as the Migration Act 1958 in Australia. In this particular, I have taken a very brief what you call, though it is having a very lengthy what you call, title. It's a very lengthy title, and it is, if I read, I will have to, read this particular, title or the heading of this piece of, legislation of 1958. Though in abbreviation, I simply addressed is the Migration Act 1958. The long title of this act is known as an act relating to entry into and persons in Australia of aliens and the departure or deportation from Australia of aliens and certain other persons act. So that it's a very long what you call the title. But what is important is, my dear friends, as a student of and you should in your examination answer sheets you should write only the Migration Act 1958. That is going to be sufficient. What is important is one of the most important section of this piece of legislation is section 9 1R sub clause 1. And in this particular section, it has been ordained in the Migration Act that persecution must involve serious harm to the applicant and systematic and discriminatory conduct. That is sufficient. But we have to understand what is the concept of serious harm. The concept of serious harm has been elaborated in this particular section, that is section 9 1R sub clause 2. Earlier it was the sub clause 1, but it is the sub clause 2, and it includes, my dear friends, a threat to life or liberty, significant physical harassment or ill treatment, significant economic hardship, denial of access to basic services, denial of capacity to earn a livelihood, dilution of human dignity, creating hostile environment, or establishing some kind of a enmity among the various sections of the population, where such hardships or denial threatens the applicant's capacity to enjoy a fruitful, meaningful, pragmatic, plausible human existence. That is a violation, or that amounts to what we call persecution. So that is the import of this particular subclause. And the courts in Australia have made it clear that the list of instances of serious harm imposes a significant impediment and constraints upon what may amount to persecution. It is non-exhaustive and does not constitute a definition. It is again a very, very flexible interpretation on the part of the judicial establishment in Australia. So far, section 9 1R sub clause 2 is concerned of the Migration Act of 1958. So it is very important. Whatever may be the listed instances and the causes which have been appreciated, it is the judicial opinion in Australia that this kind of an expression or elaboration on the grounds does not constitute a definition. It is similar to the understanding that has been there on the part of the drafters of 1951 UN Convention relating to the status of refugees with its additional protocol of 1967. So it is equally important, my dear friends, again in Australia, despite the fact the legislation is there, but the different grounds, so far the actions are concerned, so far the mens rea and actus reus is concerned. Even this is my understanding, judicial establishment very judicially refrained from providing any kind of a definition or giving or attributing this kind of a nomenclature as a part of definitional understanding. So this has really what we call done a good what we call job, because human rights have considerably been widened, and the ambit of protection afforded to what we call persons generally has also gone into sea change. Therefore, new areas are emerging, new denials are emerging, new challenges are emerging, systematic discrimination, sustained discrimination, targeted discrimination, unwritten discrimination, racial discrimination, injusticial discrimination, all forms of discriminations are taking place. And therefore, in such a situation, it becomes very, very imperative on the part of what we call the judicial establishment that they should not attribute any kind of a what we call to any kind of a nomenclature that has been presented before them in the form of a clause, in the form of a section, or in the form of a legislation. So we should refrain from defining, and that is the beauty of not having a definition of this kind of a terminology, which is known as persecution, because the convention is based on, my dear friends, on humanitarian ideals established in the concept of human rights. This particular point should not be forgotten, as I have, if you recall, what I have stated in previous semester, in the third semester, when we were discussing international human rights law norms, if you recall, that we will continue to what we call discuss international human rights law framework, even in the area of international refugee law. It was this contention on my part that we cannot, because if you study the preamble of this particular convention of 1951 relating to the status of refugees, along with its additional protocol, you will find that there is a linkage. There is a unbreakable, inalienable, indispensable linkage between the two streams of our understanding, and that too, which is one is known as the human rights law framework. Therefore, it is established that the preamble to 1951 UN Convention relating to the status of refugees affirms the principle enunciated, my dear friends, further. What does it enunciate? It enunciates, my dear friend, the Charter of the United Nations Organization. And in that very charter, the UN Charter, human beings shall, my dear friends, enjoy fundamental rights and freedoms without a discrimination. So that is another important understanding that comes within the purview of refugee protection. The grounds on which persecution is recognized in the convention, we have already deliberated on those very grounds, that is race, religion, nationality, political opinion, membership of a particular social group. They are, my dear friends, are identical grounds. Identical grounds in the sense that these grounds upon which discrimination is committed are equally what we call recognized in the standards of prohibition in general international law. A connection exists, my dear friends, between persecution and the failure on the part of a state to observe certain human rights. The reference contained in the preamble to the convention, my dear friends, and particularly relating to the principle that the human beings shall enjoy fundamental rights and freedoms, may provide a particular kind of context for advancing the view that the violation of certain rights may either constitute persecution per se or evidence. It may be the evidence of the same or evidence thereof. Therefore, the discrimination on grounds of race, religion, nationality, political opinion, or membership of a particular social group may constitute persecution under international law. Persecution feared by refugees is primarily in the nature of a serious disadvantage, including jeopardy to life, physical integrity, or liberty within the meaning of Articles 31 and Article 33 of 1951 UN Convention relating to the status of refugees. Article 31, my dear friends, I hope you have already studied all the articles of 1951 UN Convention, but for the sake of refreshing your memory, Article 31 relates to threat to life or freedom, to persecution, as it has been critically appreciated under Article 1 of the 1951 Convention on Refugees. This article, Article 31 establishes a linkage between such threats and the grounds of race, religion, nationality, membership of a particular social group or political opinion. These are the grounds on which persecution is determined primarily in the sense of Article 1 of 1951 Refugee Convention. Article 31st or 31, further states, my dear friends, further, speaks of refugees who coming directly from a territory where their life or freedom was threatened. And that is in the sense of Article 1 of 1951 Convention. And at the same time, we should not forget Article 33, subclause 1, where the doctrine of non-refoulement has also been taken into consideration. And Article 31, subclause 1 has been branded by many scholars, my dear friends, as the soul of 1951 UN Convention on Refugees. Because whatever the grounds have been adumbrated in Article 1 of the 1951 Convention, all the grounds have also been repeated under this particular first clause, or the clause 1 of 1951 Convention under Article 33. The conclusion is that, or cumulatively speaking, my dear friends, that threats to life and individual freedom generally, or in relation to the grounds which have been mentioned in these articles repeatedly, constitute persecution, and that is again warranted. There are further indications emanating from the United Nations Convention on Torture of 1984. In that very, particularly I am talking of Article 3 of 1984 UN Convention against torture or on torture. I find a very, very important connection between persecution and human rights standards under this particular UN Convention against torture. Because Article 3 of Torture Convention prohibits expulsion, return, or refoulement of persons, particularly to those countries where there is a substantial risk, a fundamental risk that they will face, they fear some kind of a torture on the basis of that particular fear. And there is a possibility of receiving some kind of an inhuman and degrading treatment. Therefore, this is a statement of the principles of non-refoulement as per Article 33, subclause 1 of 1951 Convention. So there is a connection between the two conventions. And that is why, my dear friends, international human rights law framework becomes very, very important on the two fundamental principles, as Ms. Prakriti Malla has rightly pointed out and rightly understood, and that is the principle of complementarity, the principle of supplementarity, and other important what we call applications of constitutional principles. In other words, we can put it like this, that the inclusion of this particular principle of non-refoulement, and that too in a human rights instruments, my dear friends, independently, and it is axiomatic from Article 3 of the Torture Convention of 1984. And it is very much available in the entire architecture of international refugee protection regime. It reaffirms the existence of this kind element of complementarity. Above all, such an inclusion shows that the proof of a substantial risk of torture, inhuman or degrading treatment may also constitute a well-founded fear of persecution, or if it is not going to be constituted, if it is not going to constitute a well-founded fear of persecution, then it may also indicate that there is an evidence of a well-founded fear of persecution. There happens to be a very, very important, refugee, thinker or refugee rights, thinker. I am talking of Plander. So, as per the Plander's, what you call, understanding, the difference in origins and the meaning between persecution, as per the 1951 Refugee Convention on Human Rights, is a point of some significance for the asylum seeker who faces ill treatment short of persecution, because there is a very thin difference. There may be an ill treatment, but short of persecution, and there may be a what you call ill treatment that amounts to persecution. It is basically has to be appreciated on the case by or case to case cases. As per the Plander's Suggestopedia, if I am allowed to encapsulate his entire what you call refugee protection thinking, then he is the view that there is no reason in principle why such a person should be unable to rely upon the prohibition of inhuman and degrading treatment which has been opined and envisioned under Article 3 of the 1984 United Nations Convention against torture. At the same time, he has also invoked with the similar what he call identification, with the similar nomenclature. We are also having a regional understanding in the context of Europe. I mean, the European Commission's case law on that article do not imply that this kind of a persecutory practices within the municipal legal systems or within the what we call national jurisdictions should be allowed. So cumulatively speaking, there has been an understanding. If I invoke another important jurist in the area of international refugee law, in the area of human rights law, then it is equally important to consult the writings of Alexander Betts, the writings of Erika Fowler, the writings of Professor Guy S. Goodwin. They have rightly pointed out that there is a relationship, and that establishes the relevance of of international refugee law, and particularly the 1951 convention. Even Professor Hathways has re-established the relationship of this particular convention of 1951 in the contemporary circumstances. So we cannot run away from so far the ground realities are concerned. This particular convention of 1951 is even relevant in today's circumstances, despite the fact we have recently concluded two important global compacts on refugees and migration and migrants. If you further take into account, my dear friends, the case law of Human Rights Committee shows that the detention, confinement, and banishment on account of political opinions amounts to persecution. If you recall, I have shared an example from a Pakistani lady who took refuge in Belgium. So on the basis of political opinion, and she was having and appreciated the structure of harm, I mean the credibility apprehension or the credibility of apprehension, and that was appreciated by the asylum what we call determination authorities in Belgium, and asylum was extended to her. So exclusively on the basis of political opinion. It is of some kind of significance, my dear friends, if you take into account the view of the Human Rights Committee. Because Human Rights Committee, without making any kind of a reference to 1951 Convention or the Torture Convention, it makes the concept of persecution as per the Human Rights Committee it is wider one, because the province and the lines and demarcation, its geopolitical application or its stretch or the circumference of persecution cannot be determined. One point of solace, and that is a very significant point, and that has been alluded by the Committee on Human Rights, and it is basically, my dear friends, so that any denial, I am emphasizing, my dear friends, any denial associated with human rights amounts to persecution. That is the basic and the most fundamental understanding, irrespective of any kind of references. It is not at all required that there should be a policy of making some kind of references to the 9 core international human rights treaties and the obligations thereunder, or anything which is incidental, or anything that has been envisioned or connected therewith. So a simple understanding is that it is human rights, or the concept of persecution is the most, rather I am using the 2 superlative degrees at the same time, which may be grammatically wrong, but the most widest within inverted commas. So that is the scope, that is the province. Again, I am using the 2 important opposite words. Once we are saying we cannot determine the province or the circumference of the word persecution, and I am using the most widest one. Again, it is wrong. So in simply let me put it like this, that there is no possibility of determining the scope, province, circumference, operative territory of the term persecution. So therefore, in such situations, it is the predominant and the most dominant view, and that is known as the human rights based approach to persecution. And that is that is going to serve the purpose of definition. At the same time, it is also going to serve the purpose of law and relief, which should be extended to asylum seekers, to refugees, to migrants, and the people who are fleeing persecution, whatever may be the, irrespective of the fact what kind of a grounds which have compelled their relocation or human displacement. What is important is that the all pervasive application should be there of a particular approach, and that is the human rights based approach. On the other hand, my dear friends, in the contemporary circumstances, it is evident that massive violations of human rights have been taking place or has been taking place. We have been witnessing serious public disorder in many jurisdictions. Even in our vicinity right now, what is happening in Myanmar, there is no dearth of examples. What is happening in China, in Xinjiang province, what is happening to the opposition and its leadership in Russian Federation. Another important what we call jurisdictions in Latin American countries. What is happening in Brazil, in Ethiopia, in Venezuela, in Mexico, in Kazakhstan. So if you take into account the whole entire view of the world political map, you will find that all the regions, all the continents, and majority of the national jurisdictions are witnessing these kinds of public disorders. Public disorders may be in the form of the internal strife, armed conflict of a non-international character, or the civil strife, acts of aggressions, foreign domination. These circumstances generally compel people to flee across state frontiers in large numbers. I am not denying other important factors which also what we call compel people and uproot people, displace people, and that is why we are using the forced displacement of people, or rather, in other words, the forced migration. That is the most favored terminology. We have been witnessing all such kind of developments. In such a situation, I find 1951 convention application is very limited. Rather, the 1951 convention has been addressing a specific issue. And in complementarity, it is also what you call relying upon 9 core international human rights treaties. Other important frameworks, particularly the common Article 3 to all the 4 Geneva Conventions of 1949. Under international maritime law, how to rescue refugees at sea. Then international maritime law and its conventions also become relevant. Customary international law, what we call provisions, are equally what we call applicable for the protection of refugees. So we cannot study international refugee law in isolation. In terms of research and understanding, you may call it that international refugee law is an extension of international human rights law, or in other words, let me put it like this, that international refugee law is an extension of international law in a very specialized manner. And therefore, if you take into account all the issues relating to human displacement, then the causes of forced migration beyond state borders have become more complex and intense in the contemporary circumstances, and the standards of a well-founded fear of persecution by itself is inadequate, my dear friends, to providing sanctuary, shelter, some kind of a refuge to the mass number of refugees in flight or in exodus or in influx for their lives and safety all over the world. Plight of women, particularly if you take into account, we are having a separate convention, human rights conventions on married women. We are having convention on children of 1989, UN Convention on Rights of Child. So they are also coming for the rescue of the children who have been displaced or got uprooted from their habitual habitation. And therefore, the plight of women, plight of girl child, for reasons relating to what we call to their gender as victims of what we call of the systematic rape, sexual abuse, sexual assault, and discriminatory patterns of the traditional customs and behavior is a matter not addressed directly by the UN Convention on Refugees or 1951 Convention. But we cannot deny that there are no what we call women refugees. We cannot deny there are no what we call LGBTQI rights refugees. We cannot deny there is no what we call girl child refugee. All sections, all categories of refugees are there. We cannot deny there are no elderly refugees. There are, elderly refugees. There are, senior, refugees in terms of age, in terms of their frailty, in terms of what we call of their, gender, in terms of their age. There are, refugees. So other international human rights conventions are also relevant, my dear friends, and that has been what we call, established on the basis of the element of complementarity or the common pathways to extend protection to refugees. Because definition of non-discrimination in Article 3 of the Convention does not include the category of sex. That is some kind of a, infirmity according to some scholars. But that should not be taken as some kind of a, gap or infirmity. We are not going to assess on the basis of our, understanding that there are, some gaps in 1951 UN Convention. When we are, using the term, complementarity or supplementarity, then we have to supplement, we have to complement our, understanding of, refugees or refugee protection exclusively on the basis of invoking relevant provisions from a pool of international human rights law instruments. And this is how we should, try to understand. Because if you take into account in terms of, gaps, in terms of what we call of, some golden silences, we should not, forget the practices, very lawful practices of the United Nations High Commissioner for Refugees, because UNHCR, the United Nations High Commissioner for Refugees, has to recognize that the women at risk are a special category of refugee protection. And it comes from the protection, customary, practices. What has been the practices? In 1933, in 1928, in 1924, and other important what we call, stages, and at that point of time. That was, at the subsequent stage was succeeded by the UNHCR. Because some jurisdictions have also come to accept the women at risk may constitute membership of a particular social group under Article 1 Subclause 2 of 1951 Convention, and therefore the special protection measures are required for their protection. So in such a situation, if you take into account the cumulative impact of these deliberations, is there any kind of a possibility to have a basic and the most fundamental understanding of this term that is known as persecution? How should we try to understand this particular, understanding? So this is my humble submission to all of you. Whenever you find time, you should also try what exactly should be the contours of persecution. Though the grounds of persecutions we have, witnessed in different, international human rights law instruments, in the instruments of international, refugee law, and in the subject matter of the instruments of international humanitarian law, or in the juristic, writings. So as a student of international refugee law, is there any kind of a possibility to arrive at any understanding of persecution? What is the possibility? I have, tried to, accumulate my understanding in these, words. Persecution may mean, I am deliberately using the word may mean an act which causes severe harm to a fundamental human right, especially the right to life, liberty, and physical integrity. I am using three important, terms: right to life, liberty, and physical integrity. So these, I mean, if anything harms these three important notions, then it is a violation of refugee rights, resulting into persecution. Physical integrity includes each and everything, whatever has been envisioned in the 9 core international human rights and treaty obligations. Because a person's fear of persecution can relate to something which has already happened or something they think might happen, but the fear must be both subjectively and objectively rational. Because there is a possibility that the persecution could result from direct involvement of state actors, as we have been witnessing in South Asian jurisdictions. Persecution could result from non-state actors beyond the control of state. This is something we can identify in South Asian jurisdictions. And again, persecution could also result from non-state actors tolerated by state. As I have been, emphasizing this entire what we call, trajectory, and that is why, on the basis of these, notions, I have what we call, came out with our, understanding of what we call, of persecution. Because Article 2, if you take into account, if you what we call having some kind of a dissection of entire 1951 convention, then you will realize that there are other 45 articles. And if you take into account Article 2, my dear friends, after Article 1, you will find that there are general obligations to conform to the law, which has been what we call the yardstick provided under Article 2. And if you take into account another set of what we call of articles of 1951 convention, allow me to begin from Article 12 up to what we call Article 16. You'll find that there are deliberations and dimensions and discussions on the legal nuances relating to the juridical status of refugees. And there are another important set of articles that begins from Article 17 and goes up to Article 19. In these articles we find the livelihood what we call orientation or avenues which have been provided, and that is popularly known as the gainful employment for refugees in the country of destination, in the country of reception, or in the country of asylum. And there is another important what we call set of articles that comes from Article 20 and goes up to what we call Article 24, which is exclusively devoted to an idea of what we call of refugee welfare. But these are some of the important what we call articles, chapters in the form of groups, in the form of what we call their cumulative impact, and specifically addressing the different what we call requirements of refugees, and at the same time providing a range of rights to refugees for their highly dignified existence in the country of reception are in violation in any geopolitical entities. And so far, another important what we call one of the most important what we call doctrine that begins from Article what we call 33, though I'm not denying the importance of Article 31 of 1951 convention related to the status of refugees, but Article 33, particularly the Article 33 becomes very, very important, where we find the soul of the convention, and it is equally applicable in all kinds of human rights violations, and that is the non-reform. It means there should not be any kind of a forced deportation, expulsion of any alien, any foreigner in the country of what we call, reception. And there should not be a policy which is known as the pushback policy, which has been, pursued by many geopolitical entities in the initial days. Initially, I mean, immediately after the conclusion of the 1950 convention, when the international, what we call, idea of refugee protection, he started gaining some kind of a momentum, he started gaining some kind of a ground, and the geopolitical entities of the different, what we call, I mean, governance structures in terms of philosophy, in terms of ideologies, they started recognizing the importance of refugee protection. So during those period, immediately after the conclusion of UN Charter, and particularly the conclusion of the 1951 Charter in 1951, so this has been the trend of recognizing refugees and the requirements of an international character. So Article 33 that prohibits expulsion or forced what you call return of refugees country of what you call origin, because in such a situation, if there happens to be any kind of violation of Article 33, then it is going to be a violation of the Universal Declaration of Human Rights, particularly Article 14 of the Universal Declaration of Human Rights, the right to seek asylum, and in another what we call country, then Article what we call 13 is equally important to the Universal Declaration of Human Rights. So there is a gap, a time frame is there. Universal Declaration of Human Rights has been accepted, concluded, I mean, recognized and adopted by the Community of Nation States in 1948 on 10th of December. You are already elected, you have been studied in your international human rights law process. But the convention, that is, an extension, basically I find it an extension of these two important articles, Article 13 and 14 of the Universal Declaration of Human Rights. Then in my sense, though there you will find another important extensions of the same what we call declaration, that is the Universal Declaration of Human Rights, and many other important articles of the 1951 Convention happens to be identical in nature what we have studied in the form of Universal Declaration of Human Rights. So the principle of non-refoulement becomes very, very important. Even the principle of non-refoulement has also been adopted invariably in all the constitutions of South Asia. Whether it is the constitution of Nepal, whether it is the constitution of Maldives, whether it is the constitution of Sri Lanka, or the constitution of Afghanistan, you will find, including the rest of the South Asian jurisdictions, you will also find that these jurisdictions have been there for the protection of non-nationals, foreigners, aliens, non-citizens, stateless people. So it is the majesty of our constitutionalism, South Asian constitutionalism, or the American constitutionalism, or the European constitutionalism. You will find that even in the absence of a well-established refugee law or the law on the refugee protection, national jurisdictions and their constitutions have been robust enough to provide all kinds of protections to these people on the move. Therefore, Article 33 subclause 1 incorporates this fundamental principle of non-refoulement, and it is the most important and guiding what we call principle, a moving principle, a performing principle, and thereunder, whenever somebody becomes, or some geopolitical entity becomes privy to 1951 convention, becomes signatory to 1951 convention, or not signatory to 1951 convention, then it is the national constitution as well as the customary international law principle, because the principle of non-refoulement as per Article 33 of late has already started the full-fledged status, according to some what we call scholars, the status of customary international law. It has become some kind of a preemptive norms of international law, some kind of a just cautions, and there is a there is another important what you call, fraternity of international refugee law scholars who are opposing that it is not what they call, just cogence or the preemptive norms of international law, but the people who are siding with its what you call, having this particular, notion that it has become the part of what you call the preemptive norms of international law. They happens today in majority, and they have been what you call, espousing the cause of what we call the supremacy, majesty, and integrity of this fundamental principle, and that is known as the non-forma. There is every possibility you may have a question on this particular, fundamental principles, and let me give you a basic understanding of Article 33, because I consider, as a student of international refugee law, you have every right to disagree with me. I consider Article 33 subclause 1, but I am having some reservations about subclause 2 of the same article, because that gives some kind of, unfettered powers to the national governments to deny the entry or to what you call, deprive such people of any kind of refugee status. So Article 33 subclause 1, my dear friends, that goes like this with inverted commas. Let me read it for you and try to understand. I would be very slow in reading. No contracting state shall expel or return a refugee in any manner whatsoever to the frontiers of territories where his life or freedom could be threatened on account of his race, religion, nationality, membership of a particular social political opinion. 5 important grounds have been incorporated. Without any kind of exception. And I am of the view that because of some political bickerings in 1951, I think the second clause has been added. Otherwise, it was not at all required. Article 33 should have been without any kind of exceptional clause. And there is a exception that has also been provided in the second important clause. And Article 33 subclause 2 goes like this: the benefit of the present provision may not, however, be claimed by a refugee whom there are reasonable grounds for regarding as a danger to the security of the country in which he is, or who, having been convicted by a final judgment of a particularly serious crime, constitute a danger to the community of that very country. There have been different interpretations to this kind of a clause. Serious crime constitute a danger to the community of that very country. I mean, country of origin, country of nationality, or homeland. Because if you take into account what has been the state behavior of different what you call nation states. Suppose if somebody has been convicted exclusively on the basis of majoritarian narrative as being witnessed in some kind of a, what you call majoritarian, countries like Pakistan, like in Sri Lanka, and other what you call nation states, where a particular religion is constituting the majority of the people, and where we find that even in the absence of the credible evidences, if somebody has been convicted of a crime which happens to be not a crime in the stricto sensu, exclusively on the basis of decent, on the basis of disagreement, on the basis of political opinion, on the basis of a membership of a particular social group, or on the basis of some other important harms. But in the estimation of the government, in the estimation of law enforcement authorities, or some other exterior, or because of some other important alternative, motives, somebody has been convicted. So in such a situation, it should not be the criteria to deny, deprive that individual of certain important rights if that knocks the doors of another country and seek refugee status or asylum. Because what may be a political offense, there is every possibility it may be a legal offense for the country of origin. It may be legal offense for the country of reception, but it may be a political offense for the country of origin. So legality and politicality has always been a very, very subjective deliberation whenever there is a question of granting refugee status to refugees, and it has been the problem invariably of all the national jurisdictions. So that is the importance of non-refoulement. It is subsequent that no papers should be asked for, no questions should be asked for, no determination should take place at the border. If somebody is knocking the doors and fleeing persecution, then there should not be any kind of a subjectivity on the part of what you call the country of reception. There should not be any kind of element of objectivity on the part of what you call country of reception. Rather, he should immediately at the border be allowed to enter into, and it is the subsequent what we call exercise how to determine or with regard to the determination of the refugee status. At the borders, what is important is the fundamental principle of non-refoulement under all circumstances be what we call allowed, and that should be the motto of all the geopolitical entities at international level. If you take into account so far the non-refoulement is concerned, there is a possibility there may be a direct non-refoulement policy. There may be some kind of indirect non-refoulement, because it is for the first time in a decision that has been decided by the European Court of Human Rights in TI versus United Kingdom. It was a decision exclusively relating to the admissibility of the petition. It has been opined in this particular decision, that is TI versus United Kingdom, my dear friends, that fundamentally, I'm part of European Court of Human Rights in the year 2000. The European Court of Human Rights was of the view that the fundamentally important prohibition against torture and inhuman and degrading treatment provided under Article 3, read in conjunction with Article 1 of the European Convention on Human Rights, to secure to everyone within their jurisdiction the rights and freedoms defined in that very convention. Here, the convention means the European Convention, and further, it imposes an obligation on the contracting states not to expel a person to a country where substantial grounds have been shown for believing that he would or she would face a real risk of being subjected to treatment contrary to Article 3. Again, here they are making a reference. European Court of Human Rights is making a reference to Article 3 of 1984 UN Convention against what we call torture. So, my dear friends, having regard to the absolute character of the rights guaranteed, Article 3 of the Torture Convention may extend to situations where the danger emanates from a people, group of people, or groups of persons who are not public officials, my dear friends, or from the consequences to health from the efforts of the serious illness. In such situations, somebody should not be what we call returned, refouled, pushed back, or sent back to the territories where there happens to be an imminent danger to his life, and that may amount to persecution. So that should be taken into consideration when we are talking non-refoulement, because non-refoulement becomes very, very important. I have, deliberated, I'm having a collection of many important, decisions. Those decisions would also be what we call, I will given you, and you will also, study them. So it's a very, very important, deliberation that should be taken into consideration. And inshallah, I will, continue in my next engagement with a new what we call topic, with a new what we call engagement. So thank you very much for being with me and try to understand the various dimensions of prosecution. And please do not forget what you have studied in your international human rights law classes. So thank you very much. Let me visit before I take your leave. Let me visit in your chat box. So in chat box there are no questions. So thank you very much, my dear friends, for the day. Enjoy yourself. Any questions? Thank you.
Thank you, sir.
Thank you,
You're
sir.
welcome.
Thank you, sir.
Welcome.
Thank you, sir.
Welcome. Asif Bhai, Mahir Sahib, most welcome. Jamshed Bhai. Thanks a lot. Thank you very much. Bye bye. Take care.